Hey everybody, I'm attorney Roger P. Foley, and today I'm going to talk to you about an example of what I would deem an unethical, shady attorney. Yes, folks, there are unethical and shady attorneys in South Florida. So let me tell you the story. I'm in court. I'm in a county court. An older attorney comes up to the podium and he starts off with explaining to the judge, I don't want to, all due respect to the state, and they've been kind and nice, but this case has been continued 10 times, and you've granted 2 orders previously for a specific discovery request, which is my client's medical records from the night in question, and they have not turned them over. I am ready for trial, but Judge, I feel like that there's an issue. Judge, you've signed 2 orders and they haven't given me the information. Okay. So first point, as soon as he says all that, I go, that's kind of weird, right? Because it's sort of common knowledge that if you're in the hospital or go to the doctor, that you get a copy of your own medical records, right? It's pretty common. You go, hey, I'd like to get a copy, and they give them to you. So it's not an issue. I mean, the client is sitting right next to his attorney or her attorney, and she can't drive because apparently she has seizures, but her husband's driven, and the attorney makes this big deal like, look, the husband's driven her to court 10 times and the state hasn't given us these records, and really kind of throwing the state under the bus. Now he's doing it in a nice way, but it's an underhanded, it's really not nice. It's really being disingenuous and what I think is purporting a fraud on the court, because he's saying, Judge, well, they're supposed to get that. No. The state only has to give you that information if they plan on using it against her at trial. Okay, so I start thinking, I'm like, why is this guy doing this? Like, he's a senior attorney. The guy looks like he's in his 60s. He looks distinguished. He mentioned several times, I'm usually in federal court. So he's got to be some kind of federal attorney. I'm assuming criminal, but it could be something else. I'm going, Jesus, maybe he doesn't do DUIs or something, right? Like, just send your client down to do it, or have her sign a thing, and yeah, you'll have to pay $1 a page, but you'll get it from, and then you can literally go, hey, Mr. State Attorney, look, she's epileptic. She had a seizure on the night in question. That was the reason for the accident. That's why her normal faculties seemed impaired, because she had a seizure and it was a medical issue, and it was a mistake by the police officer. He just didn't know better because his training's not that good. And then the state goes, yeah, the doctor's saying she had a seizure. They're not going to go forward. They're probably going to drop the case. So I'm like, why wouldn't he just do that? Why is he trying to put it on the state? So now I start to think like underhanded. I'm like, what is this guy doing? And I come to the conclusion. Now, I could be wrong. I don't think so. He's trying to force an error by the state attorney. What do you mean, Roger? During the course of a trial, right, a prosecutor cannot comment on the silence of a defendant, right? If a defendant doesn't say anything, if a defendant remains silent in court or when he's being arrested with police, you can't go, oh, he didn't say anything because he was obviously guilty, right? But take it a little step further. What if during the opening or the closing of a trial, after the jury's sworn in and once jeopardy attaches, right? What if he says, you know what, ladies and gentlemen, probably more likely in the closing, these records that the defense is talking about, they could have easily gotten them. Oh, wait a second, sidebar. And then Mr. Defense Attorney makes an argument for, hey, Judge, why should I have a mistrial? They inappropriately commented on my client's silence, and he has the right to remain silent and not to be judged on that silence. And the judge goes, hey, you know what? Mistrial. Now you got a mistrial. So is it a mistrial with prejudice? Will the state be allowed to try it? I don't know. That's a discretion of the court. Or maybe the state goes, you know what? We've gone through this. I don't want to go through it again. Maybe I'll give you a reckless driving instead of a DUI. Well, those are all logical things in my mind, but they're shady and they're unethical. Why? Because if you're a defense attorney, you should be proffering, right, with you proffer means you tell the state attorney's story. Hey, she's epileptic. She has seizures. She had a seizure before the incident. She had a seizure after the incident. And here's the medical records that you didn't pull, but she also had a seizure that night and it was a mistake by the police officer. She really shouldn't have been arrested. She wasn't impaired by drugs or alcohol. That's the common sense thing, right? But no. Now, you might think, well, maybe he just doesn't know. And the guy seemed weird. He goes, well, Judge, he was asking evidentiary questions in a case disposition. I'm going, what is this guy doing? He's talking about admitting evidence, and Judge would like to admit this evidence. And basically what he was asking the judge before trial, without any predicate, foundation, laying the groundwork, none of these things, he's asking the judge for a ruling on whether or not she will admit the records that he has from 2 different doctors that say that the client is epileptic and prone to seizures. Well, you can't, the judge can't make a ruling. You have to have testimony from that, right? The state has to put on his medical doctors, and he has to lay a predicate. It's a foundation to show that they're qualified, that they interviewed, that they take this information down, and then say that, the person's epileptic, they have a medical health concern, it could easily be, and then, right, that's how you do it. You don't ask for that at a case disposition. Previously, even the judge looked at him and she's just being kind, and she's like, well, you'd have to take that, testimony on that. And like, he's like, well, yeah, I don't have the doctors with me. So then he goes on to say, like, oh, let's set the trial for Tuesday. And then she goes, okay, well, all right, you're gonna have your witnesses. Well, I'll subpoena them. Well, today's Friday. He's asking for the trial on Tuesday, right after 10 continuances. Anyone who knows anything, you have to give a witness 5 days, right? 5 days is general notice for someone to show up. He says something, well, I hope the doctors aren't in South Africa or something. Just weird statement. So at first I'm thinking, you know what? Maybe this guy is just, I don't know, maybe it's past his time, Maybe he's past his prime. I don't know. I don't want to think that way, but he's just saying things that are sort of illogical, inappropriate. And so he says, Judge, no, I haven't subpoenaed them. Hopefully they're not in Africa, but I'll be ready on Tuesday. I don't know. The whole South Africa thing was a weird statement. I don't know where that came from either. So the judge then asks him, hey, did you give the state attorney your defense witness list with these doctors? No. I've just given him reports. Well, there's rules. There's guidelines in the discovery and reciprocal discovery, meaning that as a defense attorney, you have to list your witnesses before a trial. You can't list them and then they show up. Like, you can't list them on a Friday, they show up on Tuesday for trial, and the state doesn't have an opportunity to look at their curriculum, their resume, that kind of thing. So then I start thinking about it, and I come to the conclusion, I could be wrong, folks. He could just be, I don't know. He could be just off, but I'll tell you why. Because I'm listening to this and I go, why would he do this? Why would he do this? He's doing it because he's proffering a fraud upon the court. He's forcing appellate error. Why? Because all that state attorney has to do is say, when the defense attorney says his opening, he goes, look, this person could have got their medical records. Sidebar, and then he's asking, for a mistrial because they're illegally commenting on her silence. Maybe that forces the state's already picked the jury. They've already spent half of a day or a day going through this, or a day and a half. And then maybe after he gets a mistrial, the state will just go, okay, I'll give your client a reckless driving, and we'll kind of split the baby sort of thing. But folks, this is unethical. It's slimy. It's shady. Look, there might be some defense attorneys that say, oh, hey, that's just good strategy. No, that's BS. That's not ethics. As attorneys, we can proffer things. We can show a line. We can encourage reasonable doubt by creating a theme in our trial. Having the jury kind of look over here, but you can't proffer something, or you can't lead a jury down a path where that there's absolutely no possibility of that occurring. You can't go, oh, well, there was possibly a second person in the car, and start talking about that if you know that there was no second person in the vehicle. It's unethical. The Florida Bar Ethics, and I'm sure the American Bar Association Ethics, all preclude it. You can't send the jury unless there's, that doesn't have to be a lot, but there's a drop of evidence, a scintilla of evidence. You can start talking about alternative theories and alternative themes of who committed the crime, or that it's not possible your client did it. But all said and done, it starts to bother me, and I start sitting there going, what is he doing this for? Like, why would you risk your client? Because here's the reality. If the state is quick and they don't comment on that, they go, listen, we're not using any information that this defense attorney's talking about. He'll still probably try to ask for a mistrial, but if they're not using it, he's not going to get a mistrial. Now he's subjecting his client to incarceration. Just because she's had seizures before and after doesn't mean she had a seizure that night. She could have had a seizure that night, but she also could have been drunk or under the influence. So the whole thing is a fraud. I can't stand it because so many defense attorneys, we have a bad reputation as it is. It's like we're seen as used car salesmen and we're slick and shady. Look, I'm okay with slick. I don't like to be considered shady or unethical. I want defense attorneys to do it the right way. If you're a defense attorney, especially if you're a young defense attorney, you hope that you don't have a boss like that who's shady and unethical. It just bothers me. I went over to that defense attorney. I said, hey, you could just get the medical records. She goes, I know. So what that tells me is he's already looked at the medical records, right? Because if he already knows if the medical records said she had a seizure, he would have already given it to the state. There's no reason to go to a trial. There's no reason to charge your client thousands of dollars of extra. There's no reason to risk your client's freedom. So you know what? The records probably show that she didn't have it, or that she was under the influence, because there's usually an alcohol test. And he's just going to use this because he thinks that maybe they have an inexperienced prosecutor. Usually, in misdemeanor, they're less than 3 years. So you can't do it. It's so unethical. It's ridiculous. And I hope that guy hears it. I don't even know who he is. I've never seen him before. I hope he comments. I hope he reaches out and says something. And if anyone else does, I'll argue with them. It's unethical. It's the wrong thing to do. It's not winning by all means possible. It's winning the right way. Knowing your facts, taking your facts, being more creative and more prepared, and doing better legal work than the prosecutor to win the case. Not shady, trying to force an appellate error, risking your client's freedom, causing them to spend more money for a trial. It's just unethical across the board. I'm attorney Roger P. Foley. This is the first video where I sided with the state attorney's office. There are a lot of great people in the state attorney's office, but obviously I'm opposition, so I'm usually not saying all positive about the state. But in this case, I hope the state realizes what's going on. And just so you know, I did whisper in their ear, because even though he's a defense attorney and part of the defense family, he's not part of my family because he's unethical and he's shady, and that's not what we're about. Thanks for listening. I'm Roger P. Foley. God bless everybody.